Welcome to Fighting Bullies with Bill Reid.
Welcome to Fighting Bullies with Bill Reid. Bill is the senior founding partner at Reed Collins and the author of Fighting Bullies, where he challenges what law students and young lawyers are told about prestige, career paths, and success in the legal profession. Drawing on decades of experience trying high stakes cases, Bill makes the case for a different path. I'm Lisa Mosby, your host, and today we're talking about whether law school is telling students the full story about what a legal career actually looks like. Welcome, Bill. Thanks for being with me today.
Thanks for having me.
Before we get into the bigger idea from the book, can you share a bit about your own path into the law and what experiences shaped how you think about legal careers today?
I got lucky is the short answer. The long answer is that when I went to law school, I don't think it was very different than today. No one really gave me a whole lot of direction. There was these on-campus interviews that they still have today. A bunch of employers showed up. I picked what I thought was the best one for my first summer job. It stunk. I didn't enjoy it. I didn't want to work in New York after that. I didn't want to work in big law. And so I kind of pursued a different path. And then I worked in Dallas, Texas before my federal clerkship on the Fifth Circuit. I had already secured a clerkship. I at least got that part right. Then I worked in Dallas for 4 years, got a fair amount of experience with really not any kind of concentration in any subject matter. I fortunately was able to work on both sides of the V, plaintiff and defendant. But I just felt like I was always going to be the second or the third chair, not the first chair. And so, in order to remedy that, I decided at the age of 29 to be an assistant U.S. attorney, which at the time required me to go to this godforsaken hellhole called Del Rio, Texas. It is hell on earth. There are 2 restaurants, no social things to do whatsoever, no young people, and it's in the middle of nowhere. So I bought a motorcycle, a Bible, got a puppy, and a guitar, and occupied my time for 3 years. But more importantly, tried 25 jury trials. When I left Del Rio in June of 2000 as an 8-year lawyer to join a startup boutique that was a spinoff of my former Dallas firm to do what they called who killed the company cases, I finally found what I wanted to do with my career. But it was really all luck that led me there, as opposed to somebody explaining the path and then allowing me to make certain elections along the way.
And sometimes that's just how the path works, isn't it? Early in the book, you argue that law students are making career decisions with incomplete information. What do you believe is missing from the way law schools present career options today?
So, first of all, you may be assuming facts, not in evidence. I don't know that law school makes any presentation about career options. And first of all, I don't know that law schools are equipped to do that. As I put in my book, aren't a whole lot of stats on the experience of law school faculty, but the top 26 law schools in America have, on average, tenured faculty with 3.7 years of private practice experience, which means that for the most part, law school professors probably practiced as an associate in big law, maybe worked for the government, and almost certainly, by and large, were not plaintiffs' lawyers. So they're not equipped. They don't have the background or the experience to really explain what a career is like. And so I think those discussions, if they're had at all, are probably more likely to occur with a career services officer who in most part are people who have a law degree, but also people who really didn't work in private practice very long. So the people that law students might try to speak to at law school are ill-equipped to answer any of the questions. But more practically, and perhaps you could argue more nefariously, the system operates by employing graduates. And so the convenient avenue by which law schools can employ the majority of their graduates, at least when you're talking top 14 or top 25 law schools, are big law firms. They hire lots of people. So if your goal in order to maintain your status in the rankings or rise is to hire as many of your graduates as you can. Big law meets that need and meets it in droves. Whereas, in contrast, plaintiffs' firms like mine, we hire like maybe 2 or 3 people a year. So you have to do a hell of a lot more work as a law school if you want to employ a class of 200 or 300 graduates through some means other than big law. Make sense?
It does. And you pointed out that most professors have limited real world experience, practical experience. How does that affect the kind of guidance that students receive about their careers?
So again, you are assuming that there is guidance about careers, and I don't think that that's a valid assumption. I think for the most part, law schools leave their students to kind of figure it out, and they allow this on-campus interview process to take place, knowing that big law will be the largest participant in that process, and that a large number of their students will get big law jobs, which checks the box for them. They're just selling an education. And in order to make sure that they get what they need out of this process, they don't really care where their graduates go. They just want them employed. And I'm giving you a very, cynical view of the world, a very negative view of the world. But it's my strong belief that this is the case at many, if not most, law schools in America.
And there's a strong cultural narrative that prestige equals success in the legal profession. Where does that narrative come from, and why do you think it's so powerful?
Well, keep in mind, law students, lawyers in general, very risk averse people, people that have concentrated on improving their piece of paper, what other people call a resume, for their entire life, making sure every test score they've taken is the highest grade, every school they go to is the best pedigree. And so it doesn't change when those people get off the education path and onto the career path, right? So those people, and I'm talking about mostly, top law school graduates, are people that have really concentrated on status and prestige their entire academic career. Why would it be any different when they get off that kind of academic path and start their career path? They think going to a big law firm that people have heard of is the way to continue building a resume. I think very differently. I think what matters a hell of a lot more than what firm you go to is the experience you have and the ability that you possess when you go on to the next step. So if you pick a fill in the blank firm that you've heard of, Cravath, Wachtell, Quinn Emanuel, whatever firm you would put in that prestigious firm blank for yourself, at the end of the day, if you don't have experience 3 to 5 years out, and you want to move on to another job, you essentially have nothing to build upon, which is why I advocate throughout my book to elevate experience over salary and prestige.
And you mentioned many students default towards big law because it maybe feels safe or structured. But what are they not seeing about how that system actually works?
Well, hang on, before you get to that, there's another very significant attraction to big law. And that is that big law pays $225,000 to $250,000 a year to start. You can't ignore that. And so, you got very expensive legal education in America. On average, students are graduating with 223,000, I think is the last figure I saw, in student loans upon graduation. So those student loans require payments to commence the moment you get a job. So that then, I think, compels a lot of people to choose big law as a way to easily pay back their student loans. And I think the mindset is something like, well, I never made anywhere near that much money before. I got these loans coming due. And so I'm going to pick not only the prestigious path, but the one that it like seems like the most lucrative path. But what I would say to people in response to that kind of decision process is that is extremely short sighted because, yes, you'll make what seems like a lot of money for the first few years. But the question is, how do you build on that if you lack the experience that a third or fourth or fifth year lawyer might get on a different path?
And you already started in that direction, because I was asking myself, what next questions do they ask? If someone is sitting in law school right now trying to decide what path to pursue, what questions should they be asking themselves that they probably aren't being encouraged to ask?
So I think that the question needs to start with what career path could I choose that will advance me as a lawyer and enable me to get to where I want to be? So, and I only know about trial work. I don't know about transactional work or tax work or whatever other career path a big for and big law might be right for some of those paths. I don't really have a lot of experience with them and I'm not talking to them. But if you want to be a trial lawyer and you go to big law, the likelihood that you will ever see a courtroom, much less participate in anything in a courtroom, even further less likely would you ever participate in a trial. And if you do, you'll likely be a spectator. Then what do you think your experience level will be when you reach 5, 6, 7, 8 years of your career? And the answer is obvious: very little. And so I think that if you were to choose a different path, whether it be the one I chose, going to be a prosecutor, you could be a public defender. You could even go to an insurance defense firm that essentially takes its young people and feeds them to the wolves, throws them into a courtroom every day, which you'd be representing insurance companies, which would be essentially hell for an entire career, if you ask me. But you would get the experience that you would need in order to build your sea legs to be a trial lawyer. And by the way, what do you think the least likely skill a lawyer could possess in the artificial intelligence world we're about to enter or have entered already? It's trial work. It's the work of lawyers standing on their feet in a courtroom that I think will remain safe, at least for now, from artificial intelligence. All the work that big firm lawyers do at the junior levels, I think, is cannibalized by artificial intelligence. When young associates essentially are asked to do research or look at large databases and come up with information or do privilege review or draft pleadings, these are all very time intensive tasks. And in an hourly fee service model, the model that's existed in big law forever, that is highly profitable to the law firm to allow people to waste their time adding more and more bodies to the mission that young lawyers do at big law every day. But when you can push a button and obtain a better result in a matter of minutes, that is when everything changes. And I think we're very close to that. And so, what happens then to the hourly fee service model? Well, if you've read my book, you've seen my prediction is that it must change. And when it changes, it will have very drastic consequences to the big law conveyor belt from law schools.
Bill, at the core of this episode, you're challenging assumptions. If there's one belief about legal careers that you think needs to be re-examined immediately, what is it?
Well, speaking to the central theme of my book, I think a lot of people in law school, whether they be students or professors, or really even a lot of lawyers, think plaintiff's law equates to personal injury law. And that is a complete misapprehension of what's happening. There are, on every major piece of litigation in America, from the Microsoft case that David Boies handled for the federal government in the 1990s to any case involving Elon Musk, which normally has billions of dollars at stake, to any sophisticated piece of business litigation, there are lawyers on both sides. And I would posit that it is a lot more fun to be on the plaintiff side of the V, make a difference, and make a living than it is to be on the defense side of the V, simply billing an hour by hour approach and really having no skin in the game economically and ultimately representing somebody who's probably done something wrong and deserves to pay anyway. Which side would you rather be on?
Well, Bill, thank you for your insights today. That's it for today's episode of Fighting Bullies. If you're a law student or early career lawyer trying to make smarter decisions about your path, you can learn more about Bill's book at fightingbulliesbook.com. If you found this conversation helpful, subscribe, share it with someone in law school, and join us for the next time as we continue breaking down the realities of legal career paths. We'll see you then.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.